fee issue once the dust had settled on the underlying issues. So unless you think that there is a reason that would be a bad idea, what I would probably do is not be inclined to address the issue of attorney fees today anyway.
If that's your inclination, I understand it.
Okay.
I moved early on because I believe the court's instructions to us at the last hearing were any motions have to be made by that Monday.
Right.
I looked at that and I thought,
Okay.
nope, there's a motion. I should make it.
Okay.
If you don't want to hear it today, I'm not terribly offended by
You
that.
don't see that that's anyway going to prejudice your position if we don't take up the issue of attorney fees today, if we don't get to it.
I can live with that. I would like to have it addressed sooner rather than later, because I think it does affect how things go. But that is my main issue, my main concern. And as far as the underlying merits of the plaintiff's claim and declaration action, my position is as stated in my memorandum. I do think that it's worthwhile to bring to the court's attention a couple of things, mostly because I think they're jurisdictional. And I feel when there is a jurisdictional issue that I have some obligation to mention it to the court, even if I'm not arguing for it or against it. I think the jurisdictional issues include the claims based upon the idea that this is inconsistent with state land use planning statutes.
Okay.
Because those claims have to be brought to Luba. And this court doesn't have jurisdiction to rule on.
So you're saying that that is an issue that you're arguing should be presented to the Luba?
It's probably too late to present it to Luba, frankly. I'm just calling to the court's attention because as I said, I think I feel an obligation to mention to you when circumstances may prevent me from having jurisdiction over the matter. So
your position may be that time has passed for Luba to get involved, and Judge, you just simply don't have the authority to decide this issue.
On the land use plan issues.
Right.
That's a matter that deserves your careful consideration.
Okay.
Similarly, with respect to the constitutional claims that are brought, I think the court needs to look at those very carefully because I doubt that the claims are right.
Okay.
We have seen, all of us, over the last 15 or 20 years, thousands of cases thrown out that attack statutes and ordinances based upon the theory that those statutes and ordinances are an unconstitutional thing. And with very few exceptions, thousands of those have been thrown out on the theory that the claims are not right because the plaintiff chose to bring them before there was an actual enforcement action. I think that deserves your consideration very carefully here too on all of the constitutional claims. Because I think that defect runs through all of them. And finally, I'll just say that the claim based upon the two subject matter rule as far as initiative petitions is concerned strikes me as being entirely moot. Because the county has passed an ordinance, the two subject matter rule doesn't apply to ordinances. Council says in their memorandum, well, that doesn't count because the ordinance, the initiative petition, said the county doesn't have the authority to amend the petition. So their adoption of an ordinance can't possibly have amended the petition. That's in their memorandum. In their complaint, on the other hand, they make the opposite assertion, which is that the initiative is invalid because it contains a clause stating that the county doesn't have the authority to amend it, and therefore it's beyond the council's authority. And I suggest that the plaintiffs are stopped from arguing that the county commissioners don't have the authority to pass the ordinance, and that's in everything that they assert in the complaint.
What you're saying essentially is that my focus needs to be on the ordinance, and that the initiative is...
It's a matter of academic interest.
It's a matter of historical interest, but not something that this court is going to need to focus on, because the ordinance is what is going to be applied potentially against individuals in the community.
Right. If anything happens, it's going to happen through the ordinance, and that's the commissioners passed it in order to. I think they have indicated clearly that they passed it because there are some drafting errors in the petition that caused it to be ambiguous, and they were trying to clean up those drafting errors by passing it.
So we'll go ahead and assume, Ms. Hanson, you want to go ahead and deal with your issues?
Your Honor, I really don't have anything to add to Mr. Williams' statement.
Okay. Now, looking to the questions that you're indicating that the court needs to address, the first one is whether or not the ordinance is in conflict with paramount state or constitutional law. And can you address that for me?
That is one of the statutory requirements, and as far as the proceedings that the county brought to the court's attention, that would be one of the items that we would want to have answered by the court.
I was thinking that we have a podium here that might be helpful for you. You've got a lot of books there in your room, so do you remember where we put that, Gloria? Is it way in the back?
Very back of the chair.
I could surrender my seat.
Could you do that? I just need to see your whole book the entire time.
I appreciate that.
Yeah. I guess we're not going to rearrange the furniture. We'll rearrange the attorney. Okay, thank you. So your concern is that there would be exclusive jurisdiction in the state or the U.S. Constitution that would restrict the ability of the county to pass an effective ordinance?
I don't know that I'm following exactly what your question is, Your Honor. I assume that you're referring to our second amended petition
Right.
for validation?
Yes.
Okay. Is the question whether or not the exclusive jurisdiction of the court is with the petition and not with the declaratory judgment?
No.
Okay.
Whether or not there is state or federal legislation, in your opinion, that prohibits this court from, or the county from taking the actions